We still got a little bit of time left. There's some stragglers out there. It's good. Fills up kind of each of the sections. So. At that point, you just do a brown bag, that sort of thing. But no, this is really quite respectable. So.
When Patrick File had me at the University of Nevada, he was very apologetic. He was like this, and I said, it's fine.
Yeah, some will be a sellout, and some will be, but still a very respectable number. That's good. There's Casey. All's well.
Okay, good evening, everyone, and welcome to the 34th Annual Silha Lecture. Many of you know my name is Jane Kirtley, and I have the honor of being the director of the Silha Center for the Study of Media Ethics and Law, based at the University of Minnesota's Hubbard School of Journalism and Mass Communication, and we're so happy that you are able to join us tonight. This year's lecture topic is one that should resonate with everyone here in Minnesota. Public and press access to Minnesota courts, including by journalists with cameras, has been a complicated and controversial topic for many years. Although camera access rights have expanded in recent years, Minnesota continues to permit greater restrictions than in many other states, including in our nearby neighbor, Wisconsin. But cameras are only part of the story. Some judges continue to restrict access to trial exhibits, jury selection, and other critical components of our criminal justice system. I'm sure many of you know that we experienced this earlier this year during the trial of police officer Mohammed Noor. No one would dispute that media coverage can sometimes be problematic, but the reality is that reporting by independent media is often the only way to learn what this extremely important but often misunderstood branch of the government is up to. It's essential to accountability and to public oversight. Our lecturer tonight is uniquely qualified to discuss these and other issues. I'll tell you more about Kelli Sager in a few minutes, but first I want to take a moment to say thank you. The Silha Center was established 35 years ago with a generous endowment from the late Otto Silha, who was the former president and publisher of the Minneapolis Star and the Minneapolis Tribune, and his wife, Helen. They were engaged and enthusiastic boosters of the Silha Center, and we miss them very much. Happily, some members of the Silha family are with us tonight, daughter Alice Ryman and her husband, John. We are so grateful for Otto's vision and for your family's continued support for more than 30 years. I hope that the Silha Center will continue to serve as a living testament to Otto and Helen's values, vision, and memory. So thank you. Also with us tonight is the director of the Hubbard School of Journalism and Mass Communication, Dr. Alicia Cohen, who since her arrival at the school in 2017 has encouraged our work and honored us with her presence at our events. Since 1984, the Silha Center has been the vanguard of the School of Journalism and Mass Communication scholarly efforts and public outreach in the areas of media law and media ethics, and has achieved international recognition for its work. The Silha Center publishes a newsletter 3 times a year, the Silha Bulletin, which covers emerging issues in media law and media ethics, and is researched and written by Silha RAs. Copies of the bulletin are now available online only, but we hope to encourage you to subscribe. It's free by picking up a copy of the informational flyer outside the auditorium. Silha funding has supported the work of dozens of graduate and law students, fellows, and research assistants throughout the years. Our 3 current Silha RAs have all been instrumental in ensuring the success of tonight's lecture, and I'd like to thank all of them for their efforts: Scott Memel, Sarah Wiley, and Jonathan Anderson. And this event could not take place without the hard work and commitment of our program assistant, Elaine Hargrove. Every year, the Silha Center offers programs that draw the public into an ongoing discussion about ethical and legal issues facing the media. Tonight's lecture, the 34th in the series, has become the Silha Center's signature event, provides a platform for distinguished and innovative thinkers about journalism, ethics, and law, sharing their insights and expertise. And our lecturer tonight follows in that tradition of excellence. Born in Ohio, Kelli Sager began her academic career at the University of Southern California, where she majored in journalism and political science and was a star of the school's debate team. But during her junior year, following a scandal involving football players who claimed to be on the debate team but were not, she transferred to West Georgia College, where she competed in the national competition, placing 5th. From there, she went on to the University of Utah College of Law, where she was editor-in-chief of the Utah Law Review. Her spectacular career of more than 30 years as an attorney in Los Angeles, where she's currently a partner at Davis Wright Tremaine, has earned her recognition as a top lawyer by Chambers USA and the Los Angeles Daily Journal, among many other honors. She's perhaps best known for her representation of the news media during the O.J. Simpson trial 25 years ago, when she persuaded presiding Judge Lance Ito to reverse his decision to ban the press from the courtroom. Several months later, Judge Ito demanded that Kelli specifically appear before him to explain why Court TV's cameras shouldn't be shut down after it had inadvertently filmed an alternate juror during opening arguments. And as some of you may remember, they were not shut down. But in addition to her work promoting access to the courts in many high-profile cases, she's also active in cases involving libel, the right to publicity, privacy, intellectual property, and even prior restraints. She's always exceptionally well prepared and represents her clients with eloquence and good humor. As Carleen Goler, the former vice president and deputy general counsel at the Los Angeles Times, has said, Kelli is probably the best First Amendment lawyer in the West and one of the best in the country. And according to Southern California's Super Lawyers magazine, she is one of a very exclusive group of lawyers in Los Angeles. She has a lava lamp in her office. Kelli is active with the ABA's Forum on Communication Law and the International Bar Association's Media Committee and many other high-profile activities both in the U.S. and abroad. But wherever she goes, her guiding principle is that under the Constitution, the public has the right of access to the courts, and there must be a very good reason to override that principle. So let's hear more about it. Please join me in welcoming Kelli Sager.
Put my stuff together here. Well, that was a great introduction. I'd really like to start by thanking Professor Kirtley for those kind words. I didn't know she was going to mention the USC thing. That could be a whole nother hour of conversation, so we'll save that for drinks later. It's really an honor for me to be here and a pleasure as well to be here, particularly with somebody I admire and respect as much as I admire and respect Professor Kirtley. We've known each other for many, many years, even though we're both only in our 20s, so I don't know how that happened. But it is the kind of thing where when I got invited, it was immediately that I was going to say yes, because I would go anywhere that she asked me to go, and it's certainly a pleasure to be here. I also would really like to thank Elaine and the staff of the university here and for the graduate students for all of their warmth and hospitality and their assistance in putting this all together and schlepping my husband and I around. And last but certainly not least, I would like to thank the Silha family for their long-standing support of journalism and for continuing to highlight through things like these lectures the important issues surrounding the First Amendment. As Professor Kirtley said, I've been doing this for more than 30 years. I've represented journalists in media companies, including all different kinds of media companies, and it has changed over the years, starting mostly with newspapers and magazines, and then broadcasters, and now websites. The work has included all kinds of cases, but a lot of it, and my passion has really been, as Professor Kirtley mentioned, ensuring that the rights of the public and the press to have access to court records and court proceedings and other government records. And for better or worse, no matter how many cases I handle in my career, how many I've handled, how many I handle in the future, I think I will probably be best known for the work that I did representing the media in the O.J. Simpson trial. And that was a coalition of media companies who banded together, partly for cost reasons, because they weren't stupid, but also because they realized that the media would have more power if they had one voice. And I was lucky enough to be chosen to be that voice in the courtroom and outside the courtroom for the media coalition before and during the criminal trial. Sadly, if you saw the recent FX television movie or the ESPN special, there wasn't a media lawyer part in there, and I'm not really sure why not. I would have been happy to play it, but no. But it has been 25 years since Nicole Brown Simpson and Ron Goldman were murdered. And some of you in the audience may not have even been alive then or know anything about the O.J. Simpson trial. So to give you a highlight of what this trial was about and to give a refresher to those of you who were around and remembered some of the media coverage, I wanted to show a short video that can tell you a little bit about what that time period was like. Let's see if I can do this.
The Los Angeles Police Department right now is actively searching for Mr. Simpson.
I know you have a job to do, but as a last wish, please, please, please leave my children in peace. Their lives will be tough enough.
Mr. Simpson is charged alone because he is the sole murderer, and that is why he is the only one charged.
How do you plead to counts 1 and 2?
Absolutely 100% not guilty.
And do you deny each of the special allegations and the special circumstance that is alleged?
Yes.
Thank you.
The court feels that there is ample evidence to establish a strong suspicion of the guilt of the accused, and therefore the motion to dismiss is denied at this time.
Morning, Mrs. Simpson.
Merry Christmas.
Morning. Merry Christmas. See everybody on Christmas Eve?
It's hard on everybody, and I hope that in 1995 that justice will be done and that we can get a fair trial on this case. And, you know, it's real tough, and it's a real serious situation.
With the camera? No, there she is right there. She's right over there.
Be careful, you got a trio. Careful, watch the trees,
Right
guys.
down there, Mr.
Watch it, guys.
Do you agree with Marcia Clark where she says you can't trust the jury? You need a polygraph?
Absolutely not. Absolutely not. We take great umbrage. You read my comments on that? I take umbrage with that. I believe in the jury system.
But you heard, you obviously know what she said in there, that there was she would like to have a polygraph in court because you can't believe these people. They all want to be on the jury.
I don't agree with that. I do not agree with that.
I always think that having the proceedings open is beneficial, and that's one of the reasons why. I think people, when they know that there is public scrutiny, do tend to be more honest, whether they're jurors or potential witnesses or lawyers. I think everyone acts better when they know that the public and the press are watching, and that includes everybody in the process.
We share Judge Ito's concern that the facts of this case be reported accurately, and we have reported accurately the information our sources have told us.
Prosecutor Marcia Clark has denied the story, denied that any DNA testing on socks had yet been done.
This is fundamentally unfair. It's also fundamentally wrong. It impacts upon Mr. Simpson's right to a fair trial. It has the impact of polluting the jury pool because it is evidence that is not evidence. Reports of evidence that does not exist.
Get the t-shirt also! Did you get the bat?
OJ, right here! Only justice is all we ask! Don't squeeze the juice unless you're the jury! Stop domestic violence! Break the code of silence!
Here? Right over here.
I think that the public has become increasingly disenchanted with the legal justice system, especially on the criminal side, because of some highly publicized cases, which I don't need to elaborate upon here. There's a concern in the community that the criminal justice system and the courts, as being an integral part of that, are not working very well.
Remember that in voir dire, we asked you if you could use your common sense and reason to fairly and to objectively evaluate this evidence as neutral, impartial judges of the facts. You all promised that you could, and you would, and we believe that you will. We have every faith and belief in the fact that you will all keep that promise. But it will not be easy. You will be tested and tempted throughout this case to accept the unreasonable and be distracted by the irrelevant. The defense will talk to you about possibilities, and they'll insinuate many sinister things based on those possibilities. Possibilities of contamination, possibilities of setup, all in an effort to explain away all of the physical evidence. But possibilities alone do not equal proof.
And I think it's particularly unfair to Mr. Simpson to have had the prosecution throw these theories out there. And opening statements filled with half-truths and not the total facts, as you will hear tomorrow whenever we get our chance to make ours. And we don't want people anywhere to make up their minds or to judge this evidence. People heard both sides. The one thing when we approached the bench we asked Judge Ito to do is to tell the jurors to keep an open mind. It's terribly unfair to have them hear that one opening statement because of the actions of several people, to have us precluded from making our opening statement today and have the day end. That laboratory is a cesspool of contamination. Not up to speed, not up to standard. We think we can conclusively indicate that during the course of the testimony in this case. thank you very much, and I would ask you to keep an open mind until tomorrow, till we have a chance to finish. Thank you very much.
All right. As officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it. Either put Cordoba on the
Excuse
stand
me, Mr.
or
Bailey.
stop her from telling
Stand
lies.
up and speak when it's your turn. Mr. Bailey, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
And so there were too many people watching. This is by no means the only high-profile case that's come down in the last 25 years, and it's not. I don't know how to get out of this, so you may have to help me, Jonathan or Scott. What? Oh, is it? Oh, good. And it's not the only high-profile case that I've worked on during that period of time. There have been a whole bunch of them that raise very similar issues. I'll just mention a few things. I mean, you may remember the Menendez brothers, who were tried twice, once with cameras in the courtroom and once without. We worked for the media in the Sarah Jane Olson matter, where someone who had been in hiding for more than 40 years because of her work with the SLO in the 1960s was captured, and then they had criminal proceedings involving her. We worked to get records open when John Kerry was running for president, involving his wife's inheritance and whether that money was being used for campaign financing. When there was a certain senator named Jack Ryan who was getting divorced in Los Angeles, we got his divorce records open, and as a result, he decided not to run for re-election, and a certain young politician from Chicago won the Senate seat instead. He doesn't write, he doesn't call, but... And we fought to get records open in a class action suit brought against Trump University when its namesake was the leading candidate for the Republican nomination and now is the president. So there are all kinds of cases that have raised all kinds of issues about media access to the courts. But the Simpson case had so many issues that it provides a good backdrop for some of the things I wanted to talk about. And even at the time, I was struck by the irony that a double murder case was actually one of the most important First Amendment cases of that era. It led to a discussion about pretty much every aspect of the public and press's right of access to court records, to court proceedings, to visually see what's going on in the courtroom. And it will be remembered, I think, as much for those issues as it will be remembered for the criminal issues that came up during the case. And in part, that reflects things that were unique about the Simpson murders. A brutal double homicide. It was something that captured the attention right away, involving an enormously popular and well-known celebrity who was accused of the crime. Claims of domestic violence, claims of racial tension. The case had everything to hold the public's attention and the media's attention. And when you combine those elements with the largest media center in the country, Los Angeles, there was bound to be a lot of attention to what came next. But in part, I think the media attention in the Simpson trial and thereafter reflected something that had changed in the public, the amount of interest that the public had in what was going on in the courts. And I'm sort of dating myself, but it used to be when I was growing up, the only TV lawyer you ever saw was Perry Mason. And you younger people in the audience may see that now on like Nickelodeon or something, that they stream the old shows. But back then, that was what you saw when you saw lawyers. And the public's interest in lawyers and what was going on in the criminal justice process and what was going on in the courts led to all of these new fictional programs and real-life true crime programs about the law enforcement system, about criminal justice, that are now ubiquitous. And that was a reflection of what the public's interest was in all of these topics. But in the late 1980s and early 1990s, Court TV came into existence. It was a channel that had, almost overnight it seemed, 1 million subscribers, which was a really big deal for cable. It was showing coverage of actual civil and criminal trials and other kinds of proceedings all over the country. And at that time, most major news organizations had a dedicated legal reporter. Newspapers had a legal reporter or two in their newsrooms that covered the courts every day. One person for the LA Times was down every day in the federal courthouse in Los Angeles. They had another reporter who every day was staffing the Superior Court in Los Angeles. And so those people were continually covering what was going on in the courts. And Los Angeles in particular had sort of a history of high-profile criminal cases, not only the ones I mentioned, but going back even further to the John DeLorean trial, to the Charlie Manson trial. All of those occupied the headlines for weeks and months and captured the public's attention. And other states had their share during this period of time too. You had William Kennedy Smith, one of the Kennedy kids who was accused of rape. You had the Abscam trials. You had Watergate. All of those things were capturing the public's attention. But there's no question in my mind that the Simpson case was, by itself, the most highly publicized case to come along in not era or any era preceding it, and it may still be the most highly publicized case. If you saw in the video, there were structures that were built outside the courthouse for the media. So you had all of the scaffolding that had gone out outside. That was for news crews, so that everybody who was covering the case had a place for their news crew to be outside. They laid miles and miles, literally, of cable inside and outside the courthouse, wiring the courtroom, wiring a new media center that they built out on the 9th floor. They even wired the parking lot across the street so that all of those satellite trucks and media people had someplace to plug in. More than 150 reporters and editors from all over the world came to report on this trial. So whereas even in a normal trial, when there's public interest, you might have a few reporters, there were 150 of them in Los Angeles for the duration, and they represented all different kinds of countries. More than 50 media organizations had a permanent spot in the Los Angeles courthouse during the trial, for which they had to pay the cost of all these things. This was not done at public expense. The media paid to wire the courthouse, the media paid for the media center, and they paid for the privilege of being in this space for the duration of the trial. According to news reports, the day the verdict was announced was one of the most watched events in television history. It was estimated that more than 100 million people watched as the verdict was read in open court on TV. An unbelievable number of activities were put on hold, not only in this country, but all over the world. Even the president left the Oval Office to go watch television to see when the verdict came in. The Supreme Court was in session that day, and they had arranged to have one of the clerks pass them a note when the verdict came in so they would know what it was. Schools stopped classes so that students could watch as the verdict was being read. Trading volume dropped 41% on the New York Stock Exchange. And, I'm not making this up, water usage measurably decreased across the country because people were afraid if they went to the bathroom they would miss it. So, for a period of about an hour, nobody was flushing. Now, in part because of all this attention, and I honestly think because Simpson was acquitted, there was an enormous amount of scrutiny of the media and what happened with the media during this case. And the media was blamed for pretty much everything that somebody didn't like, whether about the verdict or about the trial or about the lawyer's behavior in the trial. It was somehow the media's fault, whatever it was. And I admit that my perspective is not completely objective on this because I represented the media during the trial, and I'm not saying everybody behaved perfectly, but following the trial, the result was that some lawyers and some judges, when asked sort of what the media role is in the criminal justice system, basically said, stay out of it. And I don't think that's the answer. I firmly believe that the media has a critical role to play in the judicial system. And we're in an era now where technology has made it possible for the public to have more and more information about what's going on in our courts. Yet there's a growing concern that things have been going in the opposite direction. And I'm not talking only about the fact that civics is not taught in elementary schools and junior high schools the way it was when I was growing up. The economics of newspapers in particular, because they were a driving force behind a lot of the coverage of what was going on in the courts in every little community, not just the major metropolitan centers. That decrease in newspaper coverage meant a lot of the news coverage of what's going on in the courts was also declining. The dedicated court reporters no longer exist at most major newspapers, and the staffing at newspapers has shrunk. Just for the Los Angeles Times, for example, at their heyday, they had about 1,500 reporters. At the lowest point, they had less than 500 reporters. Now with new ownership, the numbers are starting to go back up. But it takes a lot to cover a city the size of Los Angeles, and that means all aspects of it. So you don't have a person who is down in the courthouse every day knowing what's going on. Courts are said to be the least understood branch of the government, and I believe that it's true. And there are concerns about information that we hear from judges, concerns about information being on the internet, like this is a really scary thing, it's on the internet. And that, coupled with the problems with newsrooms, coupled with some, I think, still residual backlash about the O.J. Simpson trial, even 25 years later, have combined to have more sealed files and more closed courtrooms than we used to see even in a decade we're now seeing in a given year, where the news organizations that used to go in to fight these battles are not always able to go in and fight the battles in the same way. And so it's put a lot more pressure on people to fight the important fights to get this turned around. And you may ask, and rightfully so, why should we care? With all the problems in the world, why should we care whether the public is paying attention to what's going on in a courtroom or not? Well, to answer that question, I want to start by talking a little bit about the history of the court system in the US. The framers of the Constitution were well aware of what abuses can happen when courts are allowed to exercise power behind closed doors. They knew about the Star Chamber in England in the 1600s. They knew about the Spanish Inquisition. And they knew what can happen when people in a position of power can do things without the public knowing what's going on. And they also were well aware of the significant anomaly between the Star Chamber era, when courts in Great Britain were closed, and what the typical practice had been the hundreds of years before that and the hundreds of years after, where the history was in Great Britain of open court proceedings that dated back to before the Norman Conquest. So we're talking before the year 1066 when we talk about the Norman Conquest. Even back then, the cases in England were heard before what they called moots. You wonder where a moot court came from in law schools. That's what the courts were called in England back in that era. They were local courts that were attended by all, and I'm saying this in quotes, free men, because yes, they were men, and they were the same people who had all the rights. They had the property rights, they had the ability to make decisions, and they were all men at that period of time, but attending those moots was mandatory in the community. It was something that everyone was expected to do. And the reason that they were supposed to do that is so that everybody not only knew what was going on, but could contribute to the process in a positive way. Ultimately, that's where the jury system evolved from, the notion that people in the community would be making decisions about what happened to you, both on a criminal side, if something was going to be the subject of punishment, and on the civil side, if you and your neighbor had a dispute, then you would be using this proceeding instead of dueling, instead of pulling out your guns or your pistols or your swords, depending on the particular era. And the historical references, the historical records all reference the attendance of people at these criminal proceedings and at these civil proceedings. One treatise on English law notes that, and I quote, "One of the most conspicuous features of English justice that all judicial trials are held in open court to which the public has free access appears to have been the rule in England from time immemorial. And except for the blip on their history of the Star Chamber, that's the way it was for hundreds of years." And that carried over into the colonies even before the framing of the Constitution. Virginia, New Jersey, other states, historical records show, and the First Continental Congress also reaffirmed that courts were public and proceedings took place, as they say, and I quote, "before as many of the people who choose to attend." So that's the way it was then. And the combination of this strong history and the keen awareness of what happens when you allow things to be happening in secret, the terrible results from the Star Chamber proceedings and so forth, led the framers to expressly give criminal defendants the constitutional right in the Bill of Rights to a quote-unquote public trial. So that was enshrined in the Sixth Amendment when the Constitution was enacted. Now in 1979, the US Supreme Court was asked to decide whether this Sixth Amendment right to a public trial not only applied to the criminal defendant, but also gave a right of access to the public and the press. When there's a proceeding in issue where maybe the defendant doesn't want you there, or maybe somebody else doesn't want you there, can the press object to that under the Sixth Amendment? The particular issue there was a pre-trial suppression hearing where the court's deciding whether evidence will be allowed to get to the jury or not. So it was not part of the trial itself when this issue came up in 1979. And the defendant and the prosecutor and the court all agreed that the pre-trial suppression hearing had highly inflammatory stuff in it and they wanted it to be closed. So they all agreed. And the media people who happened to be covering the proceeding didn't object initially. Only when the proceeding was almost over, somebody got a lawyer that actually objected. And based on these facts, and given the concerns about that defendant's particular rights in that particular case, a majority of the US Supreme Court, when it got that far, 5-4, held that it was proper for the hearing to be closed. Now, there was a vigorous dissent by the 4 justices who were dissenting. They said that based on the history, open criminal proceedings, this was gone back for time immemorial, and also balancing the interest in this particular case, they would have said that the rights should exist for the public and press to be there, not only in talking about the Sixth Amendment, but under the First Amendment to the Constitution. And you might say, why would that be? Because when you think about the First Amendment, you think about speech and press. No one was saying they couldn't speak. No one was saying they couldn't write about it. It was a question of whether or not they would have the information to begin with. But at its core, what the First Amendment is designed to protect is an essential part of the democracy. It's the right of people to choose their government, to know what their government is doing, and to freely engage in dialogue about it. That's what the core of democracy is about. And as the Supreme Court recognized, it must protect the public's right to get information in order to protect the ability of information to be shared, whether through speech or through the press. And they've recognized this repeatedly in other contexts, whether people can advertise and give you information about things, whether it's government giving you information in Public Records Act and so forth. In the exercise of government power, to do that, you have to have the information in the first place. So in 1979, the dissenting justices said that, okay, they may have lost this round, but under the circumstances there, the majority said this guy deserved a fair trial and it would have been impacted by this information getting out. And the dissenting justices would have come out the other way, but said, well, we'll wait for another day and we'll have this First Amendment issue come up another day. And that day came very quickly because 1 year later, in 1980, the court was faced with another criminal case. Again, the criminal defendant, this time in a very notorious murder trial, did not want the trial to be public. And the media claimed a First Amendment right to be at his criminal trial. And the case was Richmond Newspapers versus Virginia. And it involved a murder trial in Hanover County, Virginia. 3 times the defendant had been tried for murder. Each time there had been a mistrial for different reasons each time. So 3 mistrials. The defendant is now facing his 4th murder trial. And the defendant's lawyer asked the court to close the courtroom. He didn't want to have any issues with jurors learning stuff they weren't supposed to know. He didn't want to have any issues about disruption in the courtroom. He didn't want to have any problems with the media at all. He thought the simplest thing to make sure everything went the way it should go, close the doors, keep everybody out, and let's just have this trial and get it over with. The prosecutor didn't care, so he didn't object, and the trial judge agreed. So they closed the trial and proceeded. Now, the Virginia state courts, the Court of Appeal, the Intermediate Court, and the state Supreme Court didn't find any problem with this either. And the case wound up in the US Supreme Court, this time squarely raising the question, do the public and press have a First Amendment right to go to a criminal trial when the defendant doesn't want you there? So his right to a fair trial, his right to a public trial was not at issue. And the court began in its decision by going through the long history that I just outlined for you of criminal trials, dating back to before the Norman Conquest. And it reads very much like the dissenting justices' opinions in the case the year before, which suddenly had become the majority under Chief Justice Berger. Now it was the majority decision that he was announcing. But they also talked about the importance of public trials, why you want to have open court proceedings. As they said, it gives assurance that the proceedings are conducted fairly to all concerned. It discourages perjury, the misconduct of participants, and decisions based on secret bias or partiality. When a shocking crime occurs, the court said, a community reaction of outrage and public protest often follows. Thereafter, the open processes of justice serve an important prophylactic purpose, providing an outlet for community concern, hostility, and emotion. And in a passage that's often cited in other cases, the Chief Justice wrote, people in an open society don't demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. When a criminal trial is conducted in the open, there is at least an opportunity both for understanding the system in general and its workings in a particular case. So the end result was that they found a presumption of openness of criminal trials that arises not from the Sixth Amendment, but from the First Amendment and the 14th Amendment as applied to the states, that cannot be abridged absent a finding of a compelling interest that justifies closing the criminal trial. And to justify this compelling interest, the trial court, they said, must articulate specific findings that show us why, because as the reviewing court, they were going to want to know why you've decided that this case outweighs the First Amendment constitutional rights of the public and press. Now, an interesting side note that I know my husband who's here knows about this case from the Richmond newspaper's case, it was the first time that Larry Tribe, who's a very well-known constitutional scholar and lawyer, it's the first time he argued in the US Supreme Court. And he describes it as somewhat of a bittersweet experience if you read his book, because his father had died shortly before the date of the argument unexpectedly. And he had planned to visit the courtroom in Hanover County, but because of his father's death, he was at the funeral and he did not have a chance to visit the courthouse where this all had happened before he went and argued in the Supreme Court. And the result of that is rather instructive for those of you in both the PhD programs and in law school, resulted in this exchange between Mr. Tribe and Justice William Rehnquist before he was the Chief Justice, where Justice Rehnquist said, so where exactly is Hanover County? Well, Larry Tribe didn't want to admit he didn't know, and so he said, well, it's some distance from Richmond, Your Honor. There was a pause, and Justice Rehnquist said, isn't everything some distance from Richmond, Mr. Tribe? So I guess the moral of that story is don't pretend to know what you don't know. But following this decision, which was a groundbreaking decision applying the First Amendment in this context, the Supreme Court then decided a series of cases where it said the First Amendment right of access applied not only to criminal trials, it also applied to jury selection, to the voir dire process, to preliminary hearings, which often is where a criminal case ends. You have a preliminary hearing, the defendant sees all the evidence that's going to come out in the trial, and the defendant decides to plead guilty, or a judge says, you don't have enough evidence to take this guy to trial, and that's the end of it. So many cases are decided at the preliminary hearing stage, and the US Supreme Court decided the public's and press's rights of access applies to those as well. What they did in determining whether these rights applied to a particular proceeding was to apply a two-part test, what they called the history and logic test. The history part was, well, was this the kind of proceeding that history had opened to the public and press? And they looked back at the history in England, the 1,000 years of history, and if it was the kind of proceeding that the public and press would have had access to in those days, well, then that test would be satisfied. And the second part of the test, the logic test, is does public access play a positive role? For things like perhaps grand jury investigations, there's a reason why those are done behind closed doors and you don't have the same rights of access. But if there's a history of allowing access and there's a good positive reason for it, then the court would say the First Amendment will give that right to the public and press. And in explaining in a case in 1986 why this would be applicable to all these different kinds of the proceedings, the court articulated the same rationale that I just mentioned that was articulated in the Richmond newspaper's case, that they said the value of openness lies in the fact that people not actually attending trials can have confidence that standards of fairness are being observed. The sure knowledge that anyone is free to attend gives us assurance that established procedures are being followed and that deviations will become known. Openness thus enhances both the basic fairness of the criminal trial and the appearance of fairness so essential to public confidence in the system. So the court recognized that the courthouse may be open. People in this room may decide you never go watch something that's happening in the court, but you know that you could. And knowing that you could and knowing that the people in that room know that you could gives you confidence that things are being done fairly, because the judge doesn't know whether someone's going to be walking in there with a notepad and reporting on it. They don't know whether people are going to be coming and watching or not. And so there's confidence that they'll be doing things the way they should be doing it because people are going to be watching. And as Marcia Clark says, when people are watching, the behavior sometimes changes. From my perspective, these principles that support public access can hardly be questioned. At every level of the judiciary, in all kinds of courts, important public rights that belong to all of us are being adjudicated. And those include not only criminal cases where your very life, your freedom may be taken away from you, but also civil cases that are deciding rights like environmental rights, voting rights, property rights, civil rights. All of those things are happening in courthouses every day. And the ability of the public to scrutinize the proceedings and to evaluate the decisions that come out of those is critical to the functioning of the democratic process. But it's an interesting question because the US Supreme Court has never said directly whether these same rights apply in all those civil proceedings, although they've hinted in some concurring decisions. Sometimes a justice will throw in a line about civil and criminal proceedings, but they have not had a case that has reached the U.S. Supreme Court where they have squarely held that the First Amendment applies to civil proceedings in the same way that it does to criminal proceedings. But that hasn't stopped the lower courts from doing precisely that. So in 1999, this decision came up squarely in a California case that we were involved in, where the Chief Justice, Ronald George, wrote for a unanimous California Supreme Court that the same First Amendment principles that apply in criminal trials apply with equal force to civil trials. This was another celebrity case. This was a case where Clint Eastwood was engaged in a contract dispute with his former girlfriend, Sandra Locke, over a palimony agreement. The trial judge decided to close the courtroom doors whenever the jury was not present. So you could hear what the jury heard, but you couldn't hear anything else. So if there was even legal argument going on, the judge said the public and press cannot come in and the doors would be locked. So the Los Angeles Times and KNBC-TV objected. The case wound up in the California Supreme Court. And I won't go into all the details of Chief Justice George's 40-page decision, which explains, again, all the historical and public policy reasons why you would have the ruling come out the way it did. But among other things, the decision recognized that just as with criminal trials, the public has to have faith in the outcome of civil court proceedings. Because of all the important areas I mentioned, those are decided in federal and state courts on the civil side, so you may never have a criminal trial. And he quoted Justice Brandeis writing years ago that sunlight is the best disinfectant. It says every bit as true, he said, in civil courts as it is in criminal courts. This is a landmark decision that's now been cited by other courts across the country, federal and state courts. It hasn't yet got up to the U.S. Supreme Court, but up more than 160 times, Chief Justice George's decision has been cited. And of all the work I've done over the years, I think this is the decision that I'm the most proud of. But the principles that it stands for are even more important today. When you look around at what's going on in courts today, in a political environment that is, shall we say, sharply divided, to say the least, the courts are where people are going to look for fairness and impartiality. It's where important decisions are being made that will affect all of us. And if the public doesn't trust the process or believe in the integrity of the result, then what the courts are doing is going to be meaningless. And if you don't know what's going on behind closed doors, if the courts are not doing this openly, then you're not going to trust the process or the decisions that come out of it. In California, after the Clint Eastwood case that I mentioned, they adopted new rules on sealing of documents, on secrecy, that require judges to apply those very strict constitutional standards that I mentioned before they grant any party's request to seal documents. Because it used to be fairly commonplace that the parties would agree with each other that, we'll just seal everything so that, these pesky reporters can't get it. And the judge would just rubber stamp whatever the parties said. And so the parties having made this agreement, the judge rubber stamping it, then the records would never see the light of day. Now, that's no longer allowed in the courts in California. And when it's discovered that something like that has happened, then the appellate courts immediately step in. Because whether the parties are next door neighbors or whether one of them is, say, the former chairman of a major political party who happens to be in a lawsuit with a former mistress, the public needs to know that the standards that are being applied, the rules that are applied to those people are just the same. If it's a celebrity criminal defendant or a wealthy criminal defendant, you want to know that they're getting the same rules, the same treatment as the people who don't have those advantages. And now you've got proceedings going on that involve people that are very high political office or connected to people who are in very high political office. And imagine if those cases, if those proceedings were happening where nobody knew anything but the result. How would the public and press feel about the fairness of those proceedings? And I don't blame the lawyers. It's not the lawyer's job for a particular party to be acting out for the public. The lawyers are there as advocates for their particular clients. They're not looking out for the interests of the public in general. And I learned this, I think, most markedly during the Simpson case, because depending on who had a particular point of view, I was either welcomed when I showed up at the door as a dear friend or treated as somebody's worst enemy. So the first time I went down there on one of these matters, I was greeted at the door by one of Mr. Simpson's lawyers, Bob Shapiro. Members of the defense team were so happy to see me. I argued for public access to the hearing and for a transcript of what had happened while the doors were briefly closed, which Judge Ito wound up granting. And the defense team was on my side. They were patting me on the back. They were happy. And the prosecution was not very happy that I showed up. And it turned out, as indicated in one of the clips, that in the transcript it showed that Marcia Clark had made a joke, she said, about polygraphing the jury because you can't trust jurors. And she said, I meant it as a joke. The defense team said she did not mean it as a joke. She was dead serious, and they wanted to make sure that statement got out in the public and that everybody knew that was what she thought about the jury. Less than 2 weeks later, I was back in court again. This time, I was arguing that the public and press should be allowed to attend a hearing on whether Simpson's friend and a minister, Rosie Greer, should be required to testify about what Simpson allegedly said to him in jail when Greer went to visit him. And the defense lawyers were vigorously opposed to this because they didn't want the public and press anywhere near this hearing. If there was going to be testimony that was going to be released during this hearing, they didn't want it to be publicized. And meanwhile, Marcia Clark gave me a big wink from across the room, nod of support, afterwards thanked me for showing up, doing the public service. And what this taught me was that the public's rights should not depend on the vagaries of particular lawyers. It shouldn't depend on a judge's particular point of view. And that doesn't mean that the media is absolved from having self-restraint, but it's a separate question from whether the government and the courts should ensure that the public and press have access. Now, there are those who say, and they have said in many of these cases, that allowing the public and press to know is going to taint the jury pool, particularly if it's involving pre-trial proceedings. Because after all, we don't want prospective jurors to be hearing about the facts of a particular case before they hear the evidence presented in court. But that idea that a juror is supposed to be ignorant of anything that's happening before they actually hear evidence really is something that's become part of a modern notion of a criminal trial. It's a luxury that came with expanding population and anonymity, really has nothing to do with the way the jury system was originally envisioned. Mark Twain was quoted, perhaps apocryphally, as saying that we have a jury system here that is superior to any in the world. It's made less efficient only by the difficulty of finding 12 men who don't know anything and don't read. And that's because trials initially were held in communities where everyone knew the accused and everyone knew the accuser. The concept was having a jury of one's peers. That embraced the view that you wanted to have people who were being tried by the king, essentially. They were being subjected to the power of the government, and you wanted people in your community who knew you to be the ones helping make that decision. You didn't want them to be strangers. You didn't want them to know nothing about what was going on. And yet somehow, as geography spread and as the population grew, this history has changed 180 degrees, so that the first thing that's done in jury selection is to get rid of anybody who might know anything about the case or anybody who's involved in the case. But as far back as the trial of Aaron Burr in 1807, the media coverage was notorious. In the 1800s, they had a lot of media coverage, and it wasn't always very nice. And the trial was being held in the Hall of Delegates because all of the courtrooms were too small for the number of people who wanted to attend. People actually said publicly, including the then president, Thomas Jefferson, that Aaron Burr was guilty, and this was widely publicized. It was later said by the US Supreme Court that there were few people in the area who had not formed opinions about Mr. Burr and the case, both public and private, from what they had read. Yet he was acquitted, and the US Supreme Court said that he had gotten a fair trial. More than 150 years later, the US Supreme Court found that a fair jury could be found for a sensational murder case that occurred in a town of only 850 people. They tried to gag the media from reporting that the defendant had confessed, and the judge, fearing that there would not be a fair trial, had said the media was not allowed to publish this information. And it went up to the US Supreme Court, which found that that violated the First Amendment. And they said that the fact that the media publishes something does not mean that a defendant cannot get a fair trial. And in fact, they've repeatedly pointed out over the years that widespread, even pervasive publicity doesn't prevent people from getting a fair jury trial. Because when you think about it, the notion that a jury can't be fair if they know anything about a case is not only historically not what the system was designed to do, but it also was fairly elitist. It assumes that judges, because I guess they're smarter and because they've got a law degree, they can put aside what they know and be fair to both sides But jurors, well, they're just average people, so they can't be fair if we let them know anything. They can't differentiate between evidence and what they hear on the 10 o'clock news. But that's actually not empirically true. It's disproven by every empirical study that's been done on it. And anecdotal evidence, when you look at some of these high-profile trials, says exactly the contrary. Jurors understand when they're instructed, this is evidence, and you're to disregard things you've heard on the news, if anything. They understand that, and they apply the law and make their decisions accordingly. This idea that jurors are going to be prejudiced also assumes that potential jurors all view legal issues and television news coverage the same way that we might. One of the Los Angeles Times reporters who covered the first World Trade Center bombing in 1993, he covered the trial, and he told me this story about the judge questioning a young woman who was in the jury voir dire, and he was asking her about all the coverage that had been in the newspapers, and she kept saying, I didn't see that, I didn't read that. And he was getting more and more cross with her because he clearly didn't believe her. And about the fourth or fifth thing he asked her in an increasingly critical voice, she turned around and asked him if he knew about a certain rap group. And he said, no. And she asked him, well, what about this group? And the judge said, I don't know that group either. And she said, see, you pay attention to what you want. I pay attention to what I want. And it was just a reminder that the jury, just even if they know something, it may not matter, but just because it's been in the press or just because it's been on TV doesn't mean that they can't be fair. It also is frankly a given that restricting access to information from the court is not going to stop the media from reporting things. The media will report on a high profile or interesting case whether or not the actual information is coming out of the courthouse. You can put roadblocks in the way, I suppose, but you're not going to stop them from doing news reports about it. It just reduces the availability of accurate information about what's going on. So all they do is cause the media to turn to perhaps less accurate sources of information or people who are leaking things to the press. A corollary of this being that the kind of gag orders that you typically see in high-profile cases, at least at the outset, where the judge is saying, I'm going to issue a gag order because I don't want anybody talking about the case, they don't work. In the Simpson case, right off the bat, there was a question about whether Judge Ito was going to issue a gag order. And he had proposed one, which he gave to the parties in chambers, behind closed doors, and even before the ink was dry, it had already leaked to the press and had been reported on, and I appeared to oppose it even before it had actually been proposed in public by the judge. Needless to say, he decided that maybe that wasn't going to work, and it would be better just to have the information that was happening in the courtroom freely accessible to everybody. If there had been a gag order, I have no doubt that that information that was going on behind closed doors would have leaked anyway, and the only question of what the court would have to decide then is whether to go after the leakers instead of dealing with what was actually happening in the courtroom. So that brings me to the last topic I'd like to address, and that's the constitutional rights of access to court proceedings. Should that include electronic access through televised proceedings or streaming audio and video on the internet? And I'll be just very brief about the history here because it's fairly straightforward. The first restriction on cameras in courtrooms came even before there was television in people's homes, before there was television news. Following the trial of Bruno Hauptmann in 1935, and he was the man who was accused and then convicted of the Lindbergh kidnapping. Following his trial, which was covered by more than 100 photographers in the courtroom, the ABA recommended barring cameras in the courts. Now, those were still photographers because they didn't have televised coverage at that point in time. But the ABA already recommended that there not be allowed to be any access to cameras at all in the courts. And in 1952, they adopted an ethical canon to forbid photography or broadcast coverage in state court trials and for any television coverage to exist for federal trials. That ban that they recommended was in place until 1978. In 1965, the U.S. Supreme Court reviewed the claim by a convicted swindler, Billy Saul Estes, that televising his pretrial proceedings and his trial had interfered with his right to get a fair trial. And at the time, it was still fairly unusual to have television news. To have television in a courtroom at all was very rare. The ABA was still firmly opposed. And the court nonetheless refused to adopt a per se ban on cameras in the courts. Although several of the jurors believed it was a per se violation of due process, the majority, they couldn't get a majority to say that. But the majority did find that the way his particular trial was held was egregious and that it violated his fair trial rights because, among other things, they had pretrial hearings with the jury present where they had 12 different television cameramen in the courtroom. They had cables and wires strung all over the place. They had a microphone pointed at the jury box in case somebody coughed or cleared their throat, apparently. And Chief Justice Warren Burger even commented that the photographers were allowed to roam at will throughout the courtroom during the trial. At one point, a photographer went behind the judge's bench to take a picture from that perspective of the judge looking out at the audience. So by all accounts, it was not handled in the way that we would have expected a fair trial to be handled. And given all of this and the fact that cameras were still very unusual, the Supreme Court said, this certainly signaled to the jury that this was an unusual case, a notorious criminal, and had to influence the end result. Justice Harlan, however, who provided the fifth and deciding vote on reversing the conviction, was prescient about where technology might go and the future of television in particular. And he wrote, the day may come when television will have become so commonplace and so normal in the affairs of the daily life of the average person as to dissipate all reasonable likelihood that its use in courtrooms may disparage the judicial process. If and when that day comes, the constitutional judgment called for now would of course be subject to re-examination in accordance with the traditional workings of the Due Process Clause. Even Justice Clark, who was not a big fan of the media, recognized the sort of temporal nature of that particular majority ruling, saying that, quote, at this time, those safeguards necessary to have a fair trial do not permit the televising and photographing of a criminal trial. However, he said, when the advances in these areas permit reporting by printing press or by television without the present hazards to a fair trial, we will have another case. Two other justices also noted the circumstances would likely change as the technology changed. When you don't need a big camera with lights and cables all over the place, then that might be a very different case indeed. And after this, it wasn't a very long period of time before states started adopting their own rules. Florida, for example, had also looked at the due process issues and concluded on their own that there was more to be gained than lost by allowing television cameras in Florida courts, as long as they were controlled, that the environment was not such that it would be disruptive. So they allowed televised proceedings back for many, many decades. And the Florida Supreme Court essentially said, look, government is a public function, and that includes the courts. And how are people going to know what it is we're doing if they're not allowed to see it? So against this backdrop, we had another, the U.S. Supreme Court in that case said that it is not inherently a violation of due process or a violation of the criminal defendant's rights if you have a camera in the courtroom. However, that's as far as they went. And in 1981, the court said in its Chandler versus Florida case involving one of the Florida proceedings, they said it does not violate the rights of a criminal defendant, in that case which was televised. There's no inherent problem with television cameras. It's all about how the judge handles it, essentially. And the result after 1981 was to allow essentially all states to start adopting their own television procedures to allow courtroom proceedings to be televised, criminal or civil, and virtually every state then adopted some form of televised proceeding, whether it was only civil, whether it was certain parts of a proceeding, or whether, as in Florida, it was everything. In Florida, they went one step further. They created a presumptive right to have television cameras in their courtroom. So a camera is allowed unless there is a finding by the judge that in that particular case, it would interfere with the ability to have a just system. And that very rarely happens. So in Florida now, most criminal proceedings and most civil proceedings, if you want to have a camera in there, if the media show up and they want to be in, then the court's going to say, yes, you can come in. And a majority of states allowed television proceedings. The courts did not go so far as to say the First Amendment required you to allow the media to be there, which I think is actually the rule that should be applied, given both the right of access that the courts have said fundamentally exists under the First Amendment, and the fact that people now get all of their news from something other than print media. Most people get their news from television, now many from the internet and social media, but even back then, it was not something that television news was really the place where the majority of people were getting their news about the courts. But the courts have not yet found that there is a First Amendment right. But it's consistent with those findings that there has not been a single reported case that I'm aware of since 1981 where a criminal defendant's conviction has been overturned because of a camera being allowed in the courtroom. So where there's no fundamental problem with it, it's all a matter of controlling it so that it's the right kind of environment for a court. Now, court TV, as I mentioned, had emerged in the 1980s and were broadcasting a lot of criminal and civil trials. Then the O.J. Simpson case happened. And unfortunately, even though it was not done over his objection, Mr. Simpson wanted a camera there. The prosecution did not object. The DA's office actually had a policy then of not objecting to having media coverage of the trials. And he was acquitted. But because of the way that particular trial happened, and I think, as I mentioned, because of the result, a lot of judges and lawyers complained afterwards that the televising of the proceedings made them look bad. It made lawyers look bad, it made judges look bad, it made the criminal process look bad. And the judges were also unhappy about things that had nothing to do with the proceedings inside the courtroom, like Jay Leno had a recurring skit on The Tonight Show involving the dancing Itos. So a member of actors who would go out and dance that looked like Judge Ito. And the judges didn't like that. They thought it was making fun of a judge and that was not appropriate. And the result was a substantial decline in the number of judges that would allow cameras to come into their courts in California and in other states where there was discretionary with the judge as opposed to Florida. States like California had lengthy hearings about whether they should just ban cameras altogether. And even after these hearings, they decided that they would not ban cameras, although they put some more controls in place, things like not showing people in the audience. They would already had a rule that you shouldn't show jurors. But many states ratcheted back their allowing of TV coverage, particularly in criminal proceedings. And so there were a handful of states like Florida that still allowed most trials to be covered. In federal courts, it was worse because despite the fact that they had done a number of studies, one 3-year study where the federal courts had tried cameras in the courts and things had gone very well in the study, after the O.J. Simpson trial in 1986, the U.S. Judicial Conference ended the experiment with cameras and effectively refused to allow any television cameras anymore in the district courts. The courts of appeal were allowed to decide for themselves whether they wanted to have cameras or not in their proceedings if the panel decided it. But there were a couple of exceptions that are worth noting because for all of the hue and cry about how bad cameras must be, there were a couple of important trials where there actually was a camera in the courtroom, except you didn't get to see it. The Oklahoma City bombing case, for example, in 1997, the federal judge assigned to the case moved the case from Oklahoma to Colorado because he felt, given the violence that had happened and given that it was a substantial number of victims, that they could not get a fair trial trying the defendants in Oklahoma. So he moved the trial to Colorado. But that meant the family and friends of the hundreds of people that were killed or injured in that bombing would not likely be able to see the trial. And so Congress actually passed a law permitting a closed-circuit television camera to be in that courtroom for the entirety of the trial that was beamed back to people in Oklahoma so that the family and friends could actually watch all of the trial proceedings. But it was not made available to members of the general public, and nor has it ever been shown since, which is a shame. Very, very well-regarded trial judge, good lawyers on both sides, and a very well-run trial from all accounts, but something that the public didn't get to see. The other one hits a little bit closer to home. When the Prop 8 case came before a federal district judge in a bench trial in San Francisco, Judge Von Walker was going to allow camera in his courtroom. In part of Ninth Circuit had a pilot program where they were allowing some district courts to start experimenting again with having cameras in the courts. And Judge Walker said he would be happy to have a camera in his courtroom. The people who didn't want the camera in the courtroom on the Prop 8 proponents' side went to the U.S. Supreme Court and they got a stay and then an order from the Supreme Court that did not allow Judge Walker to have a camera in his courtroom, purportedly on procedural grounds because they said, well, the rule wasn't clear and people thought there would not be allowed to have a camera, and so you may not have a camera in your court that is publicly broadcast. They did allow him, however, to have a camera that actually recorded the entirety of the trial, although it will not be available to the public until the year 2020, essentially 10 years after the trial. So there was a camera there, and the lawyers who were, by all accounts, very good lawyers on both sides and a very good judge. If you were lucky enough to get a seat in the courtroom, you got to see it, and supposedly in the year 2020, that will become public to everyone else. But as of this date, there were no trials, no cases in federal court that were allowed to be publicly shown. The pilot project that I mentioned started from in 2010. The Ninth Circuit decided to allow this sort of experimentation. And the U.S. Judicial Conference decided that instead of letting the Ninth Circuit do that on their own, they would then do it, and all courts, district courts in the United States could decide whether to opt into this pilot program. But they set up very specific rules, which included any party could veto having a camera in the courtroom. So the court had to opt in, the judge then had to opt in, and then the parties had to all agree on having a camera. And not surprisingly, there were not nearly as many trials being televised or proceedings being televised as people thought there might be. And they only allowed certain proceedings, bench trials, no juries, summary judgment proceedings, and things like that. From a purely legal standpoint, the issue I have with this is not only the detriment to the right of access that we've been talking about, but also the fact that because people get their news now through television or through devices, the idea of having open court proceedings is essentially turned on its head, because unless you're actually in the courtroom, you're getting things second or third hand from people who are reporting on things in the courtroom. And the availability of just a trial transcript or reading about it later is simply not the same as being there. And the U.S. Supreme Court recognized this in 1980 in the Richmond newspapers case that I mentioned. Because one of the arguments, the trial judge and the proponents of closing that criminal trial, fourth time, they said they can just read the transcript later. They don't need to be in the courtroom. And the Supreme Court said the availability of a trial transcript is not a substitute for public presence at the trial itself. As any experienced appellate judge can tell you, a cold record is a very imperfect reproduction of events that transpire in a courtroom. Indeed, to the extent that publicity serves as a check on trial officials, recordation would be found to operate rather as cloak than check, as cloak in reality, as check only in appearance. Now that makes sense, because we all know that demeanor, tone of voice, inflection, all of those things can change meaning. It's what you do to assess credibility. You look for all of those things. And it conveys important information about what the person actually is meaning to say. Now, I don't know if any of you in the audience are fans of the movie My Cousin Vinny. I think it's the best court movie ever made. But just think about that scene where Ralph Macchio is repeating in disbelief, "I shot the clerk? I shot the clerk?" And then you have the sheriff testifying, reading back, he said, "I shot the clerk. I shot the clerk." Well, that's not just fiction, because it really happened in the O.J. Simpson trial. And the thing that I mentioned about Rosie Greer was testifying that Simpson said to him, "I did it. I killed Nicole." That's the testimony that the guard said he overheard that Rosie Greer was expected to give. And in saying that that statement should not be allowed into evidence, one of Simpson's lawyers tried to creatively influence the press reporting on this by saying, "So what if he said, 'I did it, I killed Nicole'?" So inflection can be everything. And seeing for yourself how a witness comes across, the way they're saying what they're saying, or seeing like the failed experiment of O.J. Simpson trying on a glove and then saying to the jury, "It doesn't fit," that influences what you think about those proceedings. And in contrast, the civil trial in the Simpson case that was not televised resulted in a lot of misconceptions because people didn't get to see what happened. The result essentially was different. After the civil jury came out with its conclusion that he was effectively guilty, they found him liable to damages to the families of Ronald Goldman and to his sister and father who brought the case. The civil jury came out essentially a different way. People assumed why that happened was because, well, it was a trial in Santa Monica with a white jury. The other trial, the criminal trial, had been a trial downtown Los Angeles with a largely African-American jury. So that must be the reason it came out that way. Most people couldn't come watch the trial because there was a small courtroom, and even if they had wanted to come and watch it, only a few of them would have gotten in. And so they didn't understand that the evidence presented and the lawyers presenting it were very different than in the criminal trial. They didn't hear the judge explain what the burden of proof was in a civil case, and if you weren't a lawyer and you didn't understand it's a different burden of proof than in a criminal case, you might not understand that at all. But having no camera in the courtroom, having the inability to have this broadcast, didn't mean that the media coverage was better than it was in the criminal case. To the contrary, reporters who weren't actually able to be in the courtroom every day had to rely on other people telling them what happened and then writing about it because they didn't get to see it. In the criminal case, even reporters that weren't there were able to watch it on TV and understand everything that happened because they didn't have to be in the courtroom every day. And because they couldn't broadcast the trial, one particular broadcasting company decided, well, they would just hire actors and reenact the trial every day. And that's what they did. And there was a lot of criticism for them for doing that, but they thought, well, what the heck? We can't show the actual thing, so this is what we're going to do. What happened after the Prop 8 trial, when they weren't allowed to get the footage of what actually happened in the trial, Dustin Black, an actor, decided, I'll just write a play. And they did a play where they reenacted the Prop 8 trial. And then he thought, well, that wasn't interesting enough, so now we're making it into a musical. So there's a musical of the Prop 8 trial. But recall what Chief Justice Berger said in Richmond newspapers. People are not demanding infallibility from our institutions, but it's difficult for them to accept what they are prohibited from observing. And so in all of these issues, when you're talking about letting people observe what actually happens, then the only way to do that accurately and completely is if you have a camera in the courtroom that's showing people what actually happens. Now, I know Jane wanted to have some time for questions, so I don't know how I'm doing on time. So I think I should probably end here and turn it over to Jane. The one thing that I wanted to share with you all, just at the end, if I can find the last page I wanted to read. And this is a quote that's been attributed to Felix Frankfurter, because the very real issue about what happens in appellate courts, the news is much better for appellate courts, I must say, at least on the circuit level, but it doesn't change the US Supreme Court, which has steadfastly refused to have cameras, doesn't even have live audio. And Justice Felix Frankfurter was quoted as saying that he longed for the day when the news media would cover the Supreme Court as thoroughly as it did the World Series. Because he said, I believe that the public confidence in the judiciary hinges on the public's perception of it, and that perception necessarily hinges on the media's portrayal of the legal system. So the message that I think is to being sent to the US Supreme Court, and there are now congressional hearings on this, whether they should mandate cameras in the US Supreme Court, the message is that it's time to play ball. Thank you very much. I will take this.
Okay, so what we're going to do is open it up to questions from you all. We have two people, two of our Silha RAs, Jonathan and Sarah, who have handheld microphones. So if you'll raise your hand, we'll try to get to as many people as we possibly can. If you keep your questions relatively short and focused, that'll give us more time to get to people. So, questions?
Hi, my name is Phoebe, and I'm a law student. The question I wanted to ask you was, you mentioned sort of some studies that say that juries are able to kind of put aside their biases and sort of listen to the exact evidence that they've been told. I feel like I've been taught the opposite in law school, and that juries are kind of bad at following instructions, and I was wondering if you could sort of elaborate on what some of those studies found.
And I guess I should say the one thing is, if you don't believe that juries are going to do a good job, I think that's an issue with the jury system, and that needs to be sort of something we rethink in a general term. But what the studies have found essentially was looking at the end result. They saw what the jury did and then asked the judge what he or she thought of the evidence and how they treated the evidence. And by and large, the results weren't different. That the juries everybody brings their own experience to the table, as do judges. but that the things that they fastened on, the things they thought were important, that the juries weren't bringing in something from outside that caused them to decide something different than the judge did. They may have weighed the evidence differently or assessed credibility differently than the judges did, but they weren't coming in and saying, well, I understand this is what was the evidence in the trial, but because I heard from my neighbor XYZ, I'm gonna vote the other way. And that, that's been shown a number of different times in studies where they've gone back to these jurors and done questionnaires and stuff in addition. And if we don't trust them, if we don't trust them as much as we trust judges, then I think that's a bigger problem with whether we should have juries deciding these cases. But that I think is an issue for another day.
I'm Dorslyn. Okay, fine, Hello, I'm Dorslyn. I'm also a law student. So my question is about the comments that you were making about how essentially when the doors have been closed, news reporters have taken it a bit upon themselves to possibly go to less credible sources and also to reenact, create plays, things of that sort. So I feel like, isn't that a bit problematic for the ethics of journalism and for the ethics of giving the people exactly what they should be hopefully hearing if the doors were open?
Well, and part of it is, what happens is often information that's coming through leaks, where if a door is closed and they're being told, we can't actually be there and see what happens. It doesn't mean that the lawyers necessarily follow what they're supposed to be doing, and sometimes they tell people things that have happened that isn't always right. And the news people reporting on it then may assume that the information they're getting either from a leak or from a secondhand source, somebody in the lawyer's office or somebody who says that they had heard it from somebody, and they're relying on information that's simply not as good as the information if they were getting it firsthand. And you're right, the news people have to be doing their jobs as well, but it makes it very hard for them to be doing their job if you're at the same time handcuffing them so they don't get the information.
Hi, my name's Luke, and I have a question about the right to be forgotten. In criminal cases, people are often discussed, well, and I should also say I'm not a law student, so that disclaimer at the top. But people's names are brought into these cases, perhaps maybe as suspects, and then they're weeded out later, and it's found that they actually were not involved in a crime. Yet, because the media reports on these cases, their names are linked in the permanent record, on the internet or wherever, being associated with these crimes. So I think the work that you're doing is really important. My question is, do you think there should be someone on the tail end of these cases who can counterbalance someone whose name is being brought into the public eye by taking their name out of it again if they don't believe it should be there?
Well, and I guess the hard thing about that, and for those of you who are not familiar with this phrase, the right to be forgotten, there have been a couple of cases in Europe, in the European Court of Human Rights, one of which then wound up being decided against Google, that was essentially requiring Google to make disappear from their servers, so if you did a Google search, to make disappear something that no longer was a matter of public interest. And they're supposed to decide when that's the case. If you have something old about you that comes up in a Google search and you want it to disappear, you demand that Google make it disappear, and they evaluate it and decide whether there's still a matter of public interest there. It's not something that exists in the United States, and there's a question about whether they have it right or we have it right. But history and the sort of the archiving of history exists, and if you want to start wiping out pieces of it, then I think you create a real problem for the historical record. And even if somebody is brought into a case, they're accused and they're found to be innocent, or they're accused of something or just linked to something that they had nothing to do with, that's also part of the historical record. And if you're reporting on it later, all of that is relevant to the historical record. But I think trying to make it disappear creates problems not only for the sort of existence of history, but also for deciding at what point in time does that happen and who gets to make those decisions. I frankly don't want Google to be making those decisions for me, and knowing the lawyers in-house at Google, they don't want to be making those decisions either. They've now had to hire thousands of people to process all the demands that they are getting from people saying, you have something about me online that I want taken down.
Hi, Kyle. Radio. I'm curious if you can say more to the distinction between state court systems and the federal court system. And on the federal court system, what role do you think, if any, Article 3 plays in the way it's kind of designed to have this political or public insulation for judges?
I'm not sure I understand the question in terms of Article 3. 'Cause Article 3, it applies to, it's the appointment of federal judges, and you have life tenure if you're a federal judge, which you do not have in any state that I know of. Most state judges they're either appointed or elected. And the difficulty is because you have two different systems, they can make their own rules, all subject to the overlay of the Constitution. So the Constitution is going to control everything in state courts and everything in federal courts at the end of the day. But in terms of their rules could be different in every state and different at the federal level. The federal courts all get rules that are done by the Judicial Conference of the United States, and so they have fairly standard rules, although individual courts can adopt slightly different rules as well. For cameras, what that's meant is each of the 50 states makes up its own rules. Some of them, like Florida, do one thing. California gives judges discretion. Florida does not give them so much discretion. The federal courts have their own set of rules where they've all been told essentially district courts cannot have cameras except in very limited proceedings for this pilot experimental program. But appellate courts can, if they want to, live stream or televise their proceedings. As a result, the Ninth Circuit, which has sort of been at the forefront of this, the Ninth Circuit has been televising their oral arguments since 1992, and they've had them on the internet. In the last 10 years, everything is now being live streamed on their website. You can go on and find any of the hearings they've already televised. The Second Circuit in August decided that they were going to start live streaming their oral arguments. But the other circuits have variations of whether they do audio that's available or video and audio or not available at all or posted later. And so it's really very ad hoc. And if you're trying to find out something that happened in a particular court, it can be very difficult because you don't know what the rules are in that particular court, and it makes it very hard to find things. I mean, I honestly think there should be an overlay that has a presumption of allowing this kind of coverage in every court at every level. And if there's a good reason why it shouldn't exist in a particular case, then the court can make that decision. But I think it's better to have it as one uniform system under the First Amendment. I don't know if that answered your question at all, but
Hi, I'm Kathy Hansen on the faculty in the journalism school. I'm wondering, given how politicized the Supreme Court itself has become, in your opinion, do you think televising Supreme Court behavior would help or hurt the situation that we find ourselves in?
I absolutely think it would help, because the fact that it's become so politicized to me is a reason to have cameras in there. Because when you actually watch a Supreme Court argument, and I've only gotten to do it a handful of times because I don't live in Washington, D.C. My husband, who goes with me when I'm working in D.C., goes to watch the court. So while I'm in the office, he goes to watch the court. So he's seen them a lot. But everybody that I have talked to that has actually seen a U.S. Supreme Court argument has come away with the same impression about how impressive it is. And how even when the judges may make a joke here or there, they're clearly, smart and dedicated people. They talk about very important issues, and all of that is something I think the public should see. If they weren't doing their job well when they're doing it, I think the public should see that too. But I think everyone would come away with a different impression of what the court does if they actually got to watch it. But whether the court looks good or bad, honestly, there's no good reason why the U.S. Supreme Court should not be televised. And the reasons that have been offered are, the only word that comes to mind, it's not a very nice word, is lame. They're just lame. And there aren't jurors to worry about, there aren't witnesses to worry about. They say, well, lawyers might grandstand, but you're not going to use your argument in the Supreme Court to do anything other than the best possible job you can do for your client. It's too important, and lawyers know that. So they're not going to be doing ads for their client's product, which one person on the Supreme Court said, they'll just come in and say, I represent Ford, which has the #1 leading truck in America. They're not going to do that. That would be insane. The one justice actually said that they'll just hire photogenic lawyers if you put it on TV. No, they're not going to do that either. The stakes are too high. And I think it's important that everybody get to see what the decisions are that they're making and how they're making them. And I hope the Supreme Court will come to that realization itself. But there is now actually legislation being offered by one of the New York congressmen that would mandate having cameras in the Supreme Court and all appellate court proceedings. And part of the reason they're doing that is frustration, because nothing has happened in all these years and people just don't get to see what's happening.
My name is Catherine Quaintance, and I am a trial court judge. Not sure I should admit that here, but and I did have the Noor case. And I agree with you, really, that there is no justification for appellate courts not being televised. I think there are concerns in the trial court. You just mentioned witnesses, sequestration orders. You don't want somebody watching the trial that they're going to testify at the next day. And more we have serious gang cases where people are running in and out of the court with their cell phones to call their buddies and tell them how they should testify. And I think cameras in the courtroom would aggravate that situation. And I think jurors have a right to be anonymous. I feel
In every case.
Yeah, basically. I mean, we don't always have to make them, call them by numbers, but when the press is around, we do. Because they go after them like crazy, and that was my recent experience. I mean, those people wanted protection. They did not want people delving into their private lives, and they didn't want to be threatened by either party. Those are very real, pragmatic concerns, and are about keeping the trials fair.
And I completely agree with you about having fair trials. I don't disagree with that at all.
Right.
And there may be circumstances, and gang cases are one, where you don't televise everything. Now, hopefully you would agree with me that if it's a breach of contract case between Corporation A and Corporation B, there's nobody that's going to be threatened by that particular situation.
I don't think anybody wants to watch it either.
Well, they may not want to watch it, but Court TV has them on. Court TV has them on air. I mean,
paint dry. But
right now there's a. Go ahead. I'm sorry.
But, I had one other thing. I think also, if the cameras were gavel to gavel, that'd be one thing. But judges don't trust that that's what would happen. We know they'd be edited to make it more interesting and exciting, and it would then misrepresent, in our eyes, what was actually going on.
But the same could be said of a news reporter. You don't get to control what a news reporter says about the case, and they can take what a witness says and describe it in a way that may be perfectly accurate, although not complete, or they can describe it in a way that's not completely accurate and take things out of context. But the judges can't control that. What you can do is to ensure that the public has the opportunity to see the maximum amount of accurate information, and the most accurate information is going to be what actually happens. I mean, in my judgment, having a C-SPAN type proceeding where you have a camera like you do on the floor of Congress, and it just shows it. And whatever happens, they get to see it. People can tune in or not watch it, or they can watch it. But it's just showing what happens, and that's the most accurate information there is. And my concern is that, and I'm not saying this to flatter you because I don't know you, but trial judges have a very hard job, and they work really hard at it, and they're by and large really good. There's always one in a barrel, just like there are journalists that are not good that are in a barrel. But if people see what's going on, I think the respect for what the courts do and the outcomes is going to be so much more than it is where you just hear about a result. And we've had some judges in California that have gotten really negatively treated on social media and in the press because people hear a result and they don't know why that result came to the way it did. And it's because they don't see it. And nobody has the resources to stick a reporter in the courtroom to be covering the trial every day to know why the judge came to the particular decision. I think the more information about what the courts are doing, the better. I don't disagree with you that there are certainly instances, just like there are instances when sealing may be justified, although I think those are pretty limited, where you don't have a camera. For a minor victim of a sexual assault, you would not have a camera on that witness. Where you have a gang issue and there's an issue with having people know what that person looks like. Those may be circumstances where the judge rightfully says, you're not going to show this. But That doesn't mean a police officer who's testifying, who's been in the paper every day or given speeches, should then say, oh, but I don't want to be on camera. I view those as different scenarios. And it's not an all or nothing thing, or shouldn't be. The judges can make decisions about what should or shouldn't be on camera. And at least in most of the states, I think that's still left up to the judge to decide. So.
I think on that note, because we've come to 9 o'clock, I think we have to thank Kelli for her presentation this evening. We do have comment cards outside. We'd appreciate getting your feedback, and we hope to see you next year at our 35th annual Silha Lecture. Good night.